Understanding schedule. B2. Exceptions and limitations. After learning how Schedule BI lists the items that must be satisfied before closing, the next logical step is understanding Schedule B2, which details what will remain on title even after the transaction closes. If Schedule BI clears the path, Schedule B2 defines the boundaries, showing what rights or restrictions run with the land and continue to affect ownership. Schedule B2 is often referred to as the exceptions section, and it plays a vital role in Arizona title insurance. Every exception listed in this section represents something the title company will not insure against. It is the buyer's and agent's responsibility to review these items carefully and determine how they may affect the property's use, value, or enjoyment. The purpose of Schedule B2. Schedule B2 exists to disclose matters that are recorded in the county's public records and are considered part of the property's legal condition. These items can include easements or rights of way, covenants, conditions and restrictions, CC&Rs, assessments or homeowner association obligations, recorded agreements, setbacks or utility rights, mineral, oil, or water rights reservations, encroachments or boundary discrepancies. In essence, the title company is saying, we recognize these matters exist, but we will not insure against losses or disputes arising from them. For example, if there is a utility easement across the back of a property and the new owner later wants to build a pool in that area, the title company will not cover any loss if the utility company requires access or damages the area during repairs. Easements and access. Easements are one of the most common items found in Schedule B2. Under ARS paragraph 33431, easements may be created by express grant, implication, or necessity. They give someone the legal right to use another person's land for a specific purpose, such as access or utility lines. Agents should pay attention to the location and purpose of easements. A driveway easement across a neighboring parcel, for example, might be essential for access. However, an easement on the subject property could limit where structures can be placed or where fencing is allowed. Example: a buyer in Mesa discovered through Schedule B2 that a 15-foot drainage easement ran along the rear property line. Because the agent explained its impact, the buyer adjusted pool plans to avoid the easement area, preventing a potential code violation. Covenants, conditions, and restrictions, CC&Rs. CC&Rs are private rules recorded by a developer or homeowners association to maintain community standards. Under ARS, paragraph 33, 1802, Planned Communities Act, and ARS, paragraph 33, 1202, Condominium Act, CC&Rs are binding on all current and future owners once recorded. Schedule B2 lists CC&Rs as exceptions because they permanently limit property use. For example, a buyer purchasing a Scottsdale home discovered that the CC&Rs prohibited short-term rentals. Even though the seller advertised the property as an Airbnb opportunity, the title report clarified otherwise. Because the agent reviewed Schedule B2 with the buyer, the client avoided a costly mistake. Agents should remember that while CC&Rs may enhance property values, they can also restrict certain uses, making it critical to disclose these details early in the transaction. Boundary and setback issues. Schedule B2 may also reveal setback lines or recorded plats that limit where buildings or improvements may be placed. A 10-foot front setback, for example, means no permanent structure can be built within that area. These restrictions are not defects. They are part of the property's design and land use regulations. In rural transactions, Schedule B2 might include references to survey exceptions. If a title company issues a standard coverage policy, it typically excludes matters that could be discovered by a physical inspection or survey. Buyers can request extended coverage for additional protection, especially for vacant land or custom home parcels. How Schedule B2 impacts title insurance. The buyer's title policy will not cover claims or losses related to anything listed under Schedule B2. Once recorded, these items are considered of record, meaning they are public knowledge. Under ARS, paragraph 33-411, all recorded instruments provide constructive notice to subsequent purchasers. Therefore, if a buyer later claims they didn't know about an easement or restriction, the law assumes they did, because it was recorded and listed in the title report. This principle was reinforced in the Arizona Court of Appeals case Davis v. Kleindienst, 1979, where the court held that recorded restrictions constituted sufficient notice to a purchaser, even if they did not personally read them. Agents should always advise buyers to review all listed exceptions and, when in doubt, obtain copies of the documents from the title company for further examination. The agent's role. Under R42811E, an agent must disclose any material facts they know or should know that affect the property. If an agent sees a restriction in Schedule B2 that could limit the buyer's intended use, they have a duty to discuss it and recommend further review by the title officer or an attorney. For instance, if a client plans to park a boat or RV on the property and the CC&Rs prohibit it, failing to disclose this restriction could expose the agent to liability for non-disclosure. The agent's responsibility is not to interpret the legal meaning of each item, but to recognize potential conflicts, communicate clearly, and guide the client to the right professionals. Real-world example. In one Tucson closing, Schedule B2 listed an easement for ingress and egress, recorded in docket 11-1248, page 312. The buyer initially overlooked it, but the agent requested a copy and discovered the easement allowed the neighboring property owner to drive across part of the lot. The buyer decided this interfered with planned fencing and withdrew during the inspection period. Because the agent reviewed Schedule B2 early, the client avoided a post-closing dispute. Key takeaways. Schedule. B2 is one of the most critical sections of the title report. It identifies easements, CC&Rs, setbacks, and other recorded matters that will remain on title after closing and are excluded from insurance coverage. These items are not necessarily problems, but they define the rights and limitations attached to the property. Agents must review Schedule B2 early, disclose relevant information under R4281101E, and recommend professional review when clients have questions about restrictions or recorded documents. Doing so fulfills the agent's duty of care and ensures buyers enter the transaction fully informed about what they are and are not receiving.